On February 13, 2026, the United States found itself staring down an multi-front legal and political crisis triggered by sweeping federal funding cuts pushed by President Donald Trump. In the past 24 hours alone, Democratic-led states including California, Illinois, Minnesota, and Colorado filed coordinated lawsuits in federal courts seeking to block the administration from rescinding more than $600 million in public health grants, funds that were already approved by Congress and currently deployed in communities to fight disease outbreaks, control infections, and respond to emergencies. These grants, administered through the Centers for Disease Control and Prevention and other federal agencies, are the backbone of local outbreak surveillance, contact tracing, immunization programs, and emergency readiness. Now, key health departments are warning that without these funds, basic disease monitoring infrastructure, the kind that detects and responds to everything from influenza spikes to foodborne illness outbreaks, could collapse mid-year. This legal showdown is not confined to public health. Across the country last month, other federal funding fights erupted when the Trump administration attempted to claw back funds for social safety net programs, research grants, and critical community services that were previously appropriated by Congress. In January 2026, a federal judge in Minnesota blocked the administration's intended cancellation of roughly $80 million in food stamp funding, ruling that rescinding money mid-allocation was unlawful. The judge's decision underscored a constitutional principle that Congress, not the executive, determines federal spending priorities. Republicans defending the move argued it was necessary to root out inefficiencies and align federal expenditures with administration priorities, but the judiciary repeatedly found that once Congress has appropriated funds, they cannot be arbitrarily revoked without explicit legislative authorization. The stakes in this newest battle are enormous because the affected grants are not optional or purely discretionary. They are embedded in public health systems that protect millions of Americans. In California alone, officials warned yesterday that cuts to CDC-linked grants totaling more than $40 million could force layoffs in county health departments, disrupt school vaccination programs, and stretch outbreak response teams thinner than ever before. Health leaders pointed out that the next pandemic, whether influenza, measles, or a novel pathogen, does not wait for budget debates, and weakening foundational surveillance systems increases risk for everyone. Public health economists told the New York Times that a mid-cycle removal of funding could delay everything from HIV prevention programs to maternal health initiatives. Hospitals and clinics in smaller communities, already struggling with staffing shortages, are bracing for operational cutbacks if reimbursements for prevention programs are pulled abruptly. The human dimension of this conflict is immediate and visceral. Parents in Minneapolis reported that community clinics they rely on for childhood immunizations could cancel open days if federal reimbursements are frozen. Nurses in Chicago's public health department described uncertainty about whether they will have supplies for STD outreach and family health services next quarter. Directors of HIV prevention programs in Atlanta warned that losing grant funding would force them to reduce free testing hours and outreach workers, affecting thousands of clients who depend on these services. In a statement released jointly by several state health commissioners on February 12, 2026, officials declared that public health infrastructure cannot be used as a bargaining chip in political disputes. These escalating legal confrontations have also spilled outside hospitals and health departments. Last year, the Trump administration attempted to withhold billions in federal transit and infrastructure funds unless certain policy conditions were met, moves repeatedly blocked by courts. In the Northeast, the massive $16 billion Hudson Tunnel project, a linchpin of rail modernization between New York and New Jersey, sat idle for months after funding was frozen. Only after an appeals court intervention did work resume on portions of the project, illustrating how funding uncertainty triggered by executive actions can stall critical infrastructure and delay economic activity in major metropolitan regions. What makes this moment truly explosive is not only the scale of the cuts, but the administration's apparent shift toward using unilaterally imposed funding rescissions as a tool of governance. Instead of submitting formal rescission proposals to Congress, as the Impoundment Control Act of 1974 requires, the administration has increasingly attempted to extract funding changes through agency memos and executive directives, a practice critics argue violates constitutional prerogatives of the legislative branch. States now claim this approach threatens core services they depend on daily: disease prevention, food security, community health, and transportation infrastructure, and have moved to federal court to assert that appropriations are not subject to arbitrary executive reversal. As of this hour, judges in at least 2 federal circuits are reviewing state emergency motions to block the latest public health grant cuts, and legal analysts expect injunctions as soon as this week. Meanwhile, governors and state attorneys general continue to amplify public warnings about service disruptions, emergency response gaps, and looming layoffs across essential frontline workforces, making it clear that this isn't just a legal fight, it's a crisis with real-world consequences right now. This escalating legal fight over federal funding cuts did not appear suddenly. It is the product of a systematic pattern of fiscal and political conflicts that have intensified since early 2025, when President Donald Trump began aggressively using executive authority to reinterpret and withdraw federal spending that had already been approved by Congress. The roots go back to July 2025, when Trump signed the Rescissions Act of 2025, a legislative package intended to strip approximately $9 billion in federal funding from various domestic programs, including public broadcasting, international aid, community development grants, and research initiatives, a move that was justified at the time as necessary fiscal discipline. That effort set the stage for a much broader practice, the executive branch attempting to claw back, delay, or pause congressionally appropriated funds outside the traditional budgetary process. This pattern grew, increasingly entangling federal agencies, state governments, and the judiciary in bitter disputes over who actually controls the purse strings of the U.S. government. One of the earliest and most consequential flashpoints came when the administration moved to cut infrastructure funding that was already in place for major transit and construction projects. For example, in late 2025, the Trump administration froze billions of dollars in federal transit grants tied to the $16 billion Hudson Tunnel project, a cornerstone of rail modernization in the Northeast linking New York and New Jersey. That action forced project managers to idle crews and pause contracts mid-execution, creating immediate cost implications and labor disruptions. Only after governors and infrastructure authorities pursued litigation and secured a federal appeals court order was some portion of that funding released, allowing a partial resumption of work. What had been framed publicly as a routine fiscal audit, it turned into a major legal affirmation that once funds are lawfully appropriated and contracts are entered, they cannot be paused at the whim of administrative review absent clear statutory authority. Parallel to infrastructure battles were disputes over welfare and safety net programs. In January 2026, a federal judge in Minnesota blocked the administration's attempt to cancel more than $80 million earmarked for state food assistance, ruling that laws passed by Congress could not be unilaterally rescinded by the executive branch without congressional consent. That decision underscored an emerging judicial pattern. The courts were beginning to stand firmly between the administration and its efforts to reshape federal funding mid-cycle. These rulings were grounded not in partisan preferences, but in constitutional separation of powers, namely that the legislature appropriates funds and the executive executes them. By repeatedly intervening to protect congressionally directed spending, judges were setting legal precedents that resonated through subsequent challenges. The administration's justification for these funding shifts has often been couched in terms of regulatory compliance and policy alignment. Federal officials have argued that reassessing compliance standards, eligibility requirements, and policy priorities for grant programs is a legitimate part of agency oversight. In public briefings, budget directors and Office of Management and Budget officials have claimed that reviewing and redirecting funds toward high-priority outcomes falls within executive discretion. The problem, from the state's legal perspective, is that review does not inherently mean withdrawal, and cases where funding is suspended pending review have frequently outlasted any reasonable audit period, effectively converting oversight into de facto termination. Legal scholars have noted that this approach runs afoul of the Impoundment Control Act of 1974, which was established to prevent exactly this sort of executive bypass of congressional appropriations authority. The act requires that if the president seeks to rescind or defer spending, that action must be presented to Congress and authorized. Absent that authorization, funds must be released as appropriated. In Train v. City of New York, 1975, the Supreme Court held that the executive cannot frustrate congressional intent by refusing to spend funds that were mandated by statute, a precedent repeatedly invoked by state attorneys general in their filings against the Trump administration. What the public has not been widely told is how comprehensive these funding disputes have become. They span public health, welfare, infrastructure, education, environmental programs, and research grants. In many cases, legal intervention has been required not just to interpret appropriations law, but to protect programs threatened by executive reallocations. Analysis by independent budget watchdog groups in late 2025 documented more than 1,000 federal grant programs facing similar legal uncertainty, indicating that the confrontation is systemic rather than isolated, a structural dispute over whether a president has unilateral authority to alter or withdraw congressionally mandated funds without legislative approval. That historical context deepens the crisis. This is not a single lawsuit about public health grants. It is an ongoing constitutional conflict over the core mechanics of American governance, fought out in courtrooms across the nation, with millions of dollars and millions of lives at stake. The current federal funding crisis is not an abstract budget battle. It is already inflicting measurable economic and human consequences across the United States, and the fallout is visible in boardrooms, public institutions, and family households alike. In the public health sector alone, the Trump administration's proposed rescission of approximately $600 million in CDC-linked grants has put essential disease monitoring and outbreak response infrastructure on life support. Local health departments, which rely on federal reimbursements to operate surveillance and prevention programs, face imminent layoffs of trained epidemiologists, nurses, and data analysts if funding is yanked mid-calendar year. In Illinois, state health officials publicly warned on February 12, 2026 that more than 55 ongoing contracts covering strategic planning, workforce training, emergency preparedness, and infectious disease tracking could be terminated if federal reimbursements are rescinded. These are not fringe services. These are the systems that track flu trends, respond to foodborne illness outbreaks, and coordinate community vaccination campaigns. Loss of funding in the middle of a respiratory virus season threatens to leave populations exposed to preventable health risks, with downstream effects on hospital capacities already strained by workforce shortages and delayed elective procedures. Across the country, those financial shocks translate directly into employment and economic insecurity. Nurses and public health workers in county and municipal health departments have reported hiring freezes and potential furloughs as budget offices scramble to reconcile grant uncertainty with payroll obligations. A nurse working for the San Francisco Department of Public Health told local media in early February 2026 that cuts to CDC grants totaling more than $8 million could force public health clinics to scale back hours or close satellite offices used for community health outreach. In rural regions where staffing levels are already lean, each public health job represents not just a payroll entry, but access to essential care for vulnerable populations. The human toll is immediate: longer travel times for care, reduced testing availability for communicable diseases, and fewer educational programs that keep chronic conditions in check. The impact extends into education and family services as well. Federal-state partnerships in community schools, including programs supported by more than $168 million in full-service community schools grants, have already faced disruptions. In at least 11 states and Washington, D.C., officials confirmed abrupt mid-year cancellations of tutoring, after-school enrichment, dental exams, and family support services tied to those grants. Parents in communities from Detroit to Phoenix reported having to arrange alternative childcare or academic support on short notice, adding stress to families already managing rising living costs and increased healthcare expenses. These education funding disruptions affect not just children's academic outcomes, but also the broader social supports that help families stay resilient in the face of economic volatility. Small businesses are feeling pressure as well, especially those with contracts linked to federal grant programs. Consulting firms that manage community health data, logistics companies that supply public health materials, and software providers that support reporting systems all face revenue uncertainty as cascading funding decisions reduce contract volumes or delay payments. Such disruptions contribute to slower local economic activity and increased credit risk for small enterprises that depend on predictable federal flows. This dynamic is compounded by broader uncertainty in federal financial management. Construction contractors tied to delayed infrastructure funds, research labs waiting for grant reimbursements, and small, nonprofit providers all adjust staffing and investment decisions downward when federal disbursements become unpredictable. Even at the federal agency level, internal operations are strained. The partial Department of Homeland Security shut down in early February 2026, triggered by a failure to pass spending bills due to disputes over immigration and related funding conditions, left essential freight security and emergency management functions operating with unpaid staff or minimal capacity. According to reporting from Washington outlets, transportation security officers, border inspection personnel, and disaster response planners were forced to work without confirmed funding, adding stress to systems already managing competing priorities. In all of these instances, public health, education, small business, and federal agency operations, the common thread is uncertainty and disruption driven by contested funding decisions. What began as internal executive action regarding budget priorities has expanded into a crisis with real consequences for employment stability, public services, community well-being, and local economies. Millions of Americans, from public health workers and parents to small business owners and government employees, are now wrestling with the direct impact of budget decisions made in Washington, illustrating that this is not an abstract legal battle, but a concrete economic and social shock already unfolding before our eyes. Federal funding fights always come down to accountability, and the latest legal showdown over Trump's proposed cuts is no exception. But in this case, the assignment of responsibility is stark, systematic, and unabashedly political. At the center of the controversy is Donald Trump, whose administration has pursued an aggressive strategy of rescinding or delaying federal appropriations for programs already approved by Congress, a move that governors, attorneys general, and federal judges increasingly say violates constitutional boundaries and decades of legal precedent. Trump's Office of Management and Budget has justified its actions as necessary to realign federal spending with the administration's priorities, but critics argue that the real motive is punitive, targeting states and programs that do not politically align with the administration's agenda. When funding for public health, food assistance, education support, scientific research, and community services starts to vanish mid-year, the pattern cannot simply be called budget discipline. It reflects a strategic reshaping of federal support via executive action rather than through the constitutional appropriations process. This controversy traces back to the 2025 Rescissions Act, when Trump signed a law eliminating roughly $9 billion in previously authorized spending, including money for public broadcasting, international assistance, climate resilience, and community development. Those cuts were justified by the White House as necessary trimming of wasteful and outdated programs. But many of the largest rescissions disproportionately affected states and constituencies that opposed the administration's broader policy platform. This was the first major instance where the administration did not simply propose future budget changes. It pulled the plug on current obligations, creating legal and economic turbulence that would set the stage for the 2026 fighting over public health grants and safety net funding. State leadership, led by Democratic governors and attorneys general in places like California, Illinois, Minnesota, and Colorado, responded by filing lawsuits alleging that these cuts were unconstitutional. Their cases cite Article I of the U.S. Constitution, which grants Congress exclusive authority over appropriations, and invoke the Impoundment Control Act of 1974, which forbids the executive from withholding or deferring spending that Congress has directed without proper legislative approval. In the complaints filed on February 13, 2026, state attorneys general argue that mid-year rescissions, particularly of public health funds previously appropriated, represent a direct violation of congressional intent and undermine the stability of state-run public services. These suits hold the administration accountable not just for what funding it wants to cut, but how it has tried to cut it unilaterally and without legislative consent. The judiciary's response has been significant. In January 2026, a federal judge in Minnesota blocked the administration's attempt to pull $80 million in food stamp funding, ruling that the executive had overstepped by attempting to unilaterally decline spending that Congress had mandated. Other courts have intervened similarly in funding disputes. The Hudson Tunnel project's stalled investment was partially restored only after a federal appeals court ordered partial release of federal transit funds. Federal judges have emphasized that executive agencies must execute appropriated funds, not redesign or pause them because of policy disagreements with state leadership or lawmakers. The judiciary's repeated interventions illustrate that the courts are holding the administration responsible for staying within the boundaries of constitutional spending authority, a responsibility that, until recently, was rarely enforced so directly against federal agencies. Responsibility for the current public health funding battle also intersects with policy choices from Congress. While much of the focus rightly falls on the administration's decisions to revoke or delay funding, critics point out that repeated delays in appropriations bills, recurring temporary budget resolutions, and partisan gridlock in Congress have left appropriated programs more vulnerable to executive reinterpretation. Republican lawmakers, many aligned with Trump's fiscal priorities, have echoed the administration's framing of spending cuts as necessary accountability and efficiency measures, while Democrats have decried the tactic as politically motivated raiding of essential services. The contrast between public rhetoric and practical impact has widened the accountability debate. Are these funding decisions driven by legitimate budget reform or by targeted political strategy? At the local level, hospital administrators, school superintendents, and nonprofit directors affected by funding uncertainties have placed responsibility squarely on federal leadership for forcing them into crisis management mode. Their letters to lawmakers and public statements emphasize that planning was done in good faith based on multi-year appropriations. When federal funds are abruptly rescinded without warning, they argue, the losers are the people they serve, not political operatives in Washington. The controversy is far from settled. If courts ultimately uphold the administration's rescissions, it could redefine executive authority over appropriations and shift responsibility for fiscal stability toward states and local governments. If courts block these cuts, it reinforces traditional checks and balances, placing accountability on the executive for respecting constitutional limits on spending authority. Either way, the legal and political battles unfolding in real time highlight a fundamental question about who controls taxpayer money and whose priorities determine how that money is spent. In this crisis, accountability is not a matter of opinion, but a constitutional and institutional test with real consequences for millions of Americans. The long-term fallout from the legal and political battle over federal funding cuts pushed by President Donald Trump is now shaping up to be far more consequential than a single lawsuit. It's redefining how federal appropriations are administered, how courts enforce constitutional spending authority, and how millions of Americans access essential services. At the forefront of this confrontation are the ongoing lawsuits filed on February 12-13, 2026 by Democratic-led states including California, Colorado, Illinois, and Minnesota, which argue that the administration's directive to rescind more than $600 million in Centers for Disease Control and Prevention (CDC) grants is unlawful and politically motivated. Federal judges have already intervened. U.S. District Judge Manish Shah issued a temporary order blocking the cuts for 14 days, noting that the states demonstrated irreparable harm if the funding were withdrawn immediately, a ruling that preserves critical public health funding while litigation continues. If the courts eventually uphold these state challenges, the precedent would firmly reaffirm that once Congress appropriates funds, the executive branch cannot unilaterally claw them back mid-cycle without clear legislative authority. That outcome would strengthen the constitutional separation of powers, curtailing executive overreach and solidifying judicial protection for states and local governments that rely on federal appropriations for basic services. It would also signal to future administrations that funding decisions must adhere strictly to congressional intent, providing stability and predictability for multi-year programs like public health surveillance, disease prevention, and emergency preparedness. Public health departments nationwide, some of which are already scrambling to reassure employees and contractors, would gain sustained certainty that their budgets cannot be arbitrarily rescinded, allowing them to plan workforces, community outreach, and long-term disease monitoring systems with confidence. Conversely, if courts allow the administration's funding rescissions to stand even partially, the consequences could be structural and far-reaching. It would effectively expand executive discretion over appropriated funds, enabling future presidents to reinterpret or withdraw federal money based on shifting policy priorities without obtaining new approvals from Congress. This dynamic would weaken legislative power over the budget and could prompt a fundamental shift in federal-state relations, as federal agencies gain implicit authority to adjust or retract funding mid-year. States and municipalities dependent on multi-year federal grants might respond by restructuring their own budgeting frameworks, reducing reliance on federal support to mitigate future risk. This, in turn, could strain local tax bases and public services if revenue gaps are not backfilled. The broader economic impact would compound these political and institutional changes. Programs targeted by the cuts, ranging from disease surveillance and HIV prevention to transportation infrastructure, touch millions of Americans and employ tens of thousands of workers. For example, the San Francisco Department of Public Health recently reported that more than $8 million in federal CDC grants were cut, threatening HIV/STI prevention efforts and the jobs of frontline healthcare workers. Counties across California face multimillion-dollar losses that could lead to layoffs and weakened emergency preparedness if funding is not restored through the courts or Congress. Infrastructure funding battles like those fought by New York and New Jersey over the multi-billion-dollar Gateway/Hudson Tunnel project demonstrate that federal rescissions extend beyond public health into large-scale economic initiatives. Those states are suing to compel the administration to release over $15 billion in federally committed funds, warning that work stoppages could cost thousands of jobs, halt critical construction, and impose billions in new costs to secure or restart sites. This litigation underscores that federal funding conflicts are not limited to one sector. They ripple into transportation, labor markets, and regional economies. On the social side, weakening federal funding protections could erode public trust in government support systems. When essential services, public health programs, community schools, HIV prevention initiatives, disease monitoring networks are subject to abrupt uncertainty based on political dynamics, family and communities may lose faith in the stability of government commitments. That erosion of confidence especially affects vulnerable populations that depend most heavily on federal grants to maintain access to health care, education, and social services. The unresolved question now is not whether this crisis matters. It already has demonstrable impacts on people's lives, jobs, and community well-being, but how the balance of power over federal appropriations will be settled. Will the courts restore constitutional norms that prioritize legislative authority, or will they expand executive flexibility in ways that reshape how taxpayer dollars are controlled and distributed? The answer will dictate not just the outcome of this lawsuit, but the future architecture of federal funding, public services, and state government relations for years to come.